how much you heard earlier today. My name is Emerson Thompson. I'll be presiding. To my right is Judge Monaco, and to my left is Judge Kerry Evander, our newest member to the court. We have a civil case scheduled here today, Volusia County School Board versus Volusia Home Builders Association, Incorporated. A civil case, each side has 20 minutes, and the appellant may reserve as much or as little of that time as you see fit. There's a podium clock that counts down from 20, so it'll assist you. If you want to reserve time, let me know, and I'll try and assist you by just calling it to your attention how much time you have remaining. At this time, we'll begin with the appellant. Sir, you may begin.
May it please the court, I would like, on behalf of the Volusia County School Board, to reserve about 7 minutes of the
Yes, sir.
rebuttal. My name is Stephen Grimes, representing the Volusia County School Board. The County Council of Volusia County, for the first time in 1992, adopted an impact fee for schools. And in their ordinance, they set the amount of fee, and then they said that periodically, every 2 years, they required the school board to make certifications of certain information, such as student generation rates and costs of building schools and such, to the council, so that the fee would be updated periodically upon these certifications of this particular information that the school board certified every 2 years. So as a consequence, the school board adopted thereafter what became known as Policy 612, which set forth the manner in which they'd make these certifications that the ordinance required. This went on until 1997. In 1997, the County Council repealed the 1992 ordinance and set a new impact fee, and they also made new arrangements in which, in the ordinance of the 1997 ordinance, it no longer required certifications by the school board. It said it would be adjusted periodically, I think every 2 years, based for inflation or deflation, based upon the annual report of the Florida Department of Education on school building costs.
When was this particular hearing, that's the subject matter of this appeal, when was it held?
The hearing
with the ALJ?
Before the ALJ, it was in 2005.
And when was the decision of the county council that imposed the impact fee? When was that?
That was on 24th of February 2005.
What policy rule was in effect at that time from the county council as to determining impact fees and recommendations from the school board?
There was really no policy in effect, because the 1997 ordinance said that from here on, they set the fee in the ordinance, and they said that periodically, they said every 5 years, the county council would review our ordinance. At that time, we would accept recommendations of the school board and the home builders and anybody else that wanted to make a recommendation, and then we would determine if they wanted to adopt a new fee, and that's what they did.
All right. As to a subsequent policy, was that implemented in 2005, around March of 2005?
There was no new policy adopted by the school board
as to how they would determine impact fees or set the...
No. The only thing they call policy, which Policy 612, which was back in '92, it was designed to implement the '92 ordinance, which required certifications.
All right.
Now, in 1997, there were no longer any certifications required, and at the time that the school board then made its recommendation in January of 2005, based on a new study that they required, all they had the authority to do under the 97 statutes was to make recommendations.
All right.
There was no certification, no automatic re-up.
What then was in effect that allowed the school board to give testimony or recommendation to the county council at the time the decision was made?
I'm not sure I understand your question.
Was the 92 in effect, the 97, or subsequent 2005? I call it policy.
The 1997 policy was in effect when the school board approved the study that had been made to set the fee at $5,284 and to recommend that to the county council. And then 1 month later, just short of 1 month later, the county council debated this.
Right.
And Mr. Watts came before, representing the home builders, came before the county council and tried to talk the county council into a lower fee. He recommended $3,000.
Is there anything in the record that shows why this action was not brought against the county council as opposed to the school board, since, as there was testimony from the Tyndall expert, that the impact fee is what really causes the problem, not the recommendation?
No, there's nothing in the record on that. It's interesting that at the county council meeting in February, when they were considering the school board's recommendation, Mr. Watts said this, and I'm quoting directly from the minutes of the school board, or of the county council. And Mr. Watts said this: "The action which council is being asked to take is an ordinance of Volusia County and is not a rule or policy of the school district. If this is challenged, Volusia County would be the defendant and would have to refund the money if there's a decision to do this." So I don't know, I can't tell you why this suit was against the school board, but the administrative law judge was confused. And
so that was my next question about which was in effect at the time, because it appears that he was relying on a subsequently promulgated rule and not the one in effect in 97, in effect at the time the decision was made. That's
exactly correct. He was relying on the 2005 ordinance, which was subsequent to the recommendation. In other words, when the county council in February approved and accepted the fine and decided to go with $5,284, they adopted this new ordinance, which is called 2005-01. And in that ordinance, then going forward, now again it requires some certifications by the school board. But when the school board made its recommendation, and when the county council was considering that recommendation, it was the 1997 ordinance that was applicable. Now the administrative law judge was confused because he cites as the proposition for his ruling the 2005 ordinance, which was after the school board made its recommendation. All the school board could do under the 1997 ordinance was make a recommendation, and a recommendation really by definition can't be a rule. A rule, as the court has had in a number of cases, is got to have some binding effect going forward. And merely recommending something, the county council had total authority to accept whatever figure they wanted to. In fact, there was a motion at the county council meeting by one of the councilors that let's set it at $3,100, and that was defeated by 5-2, and then they went ahead and adopted the 5284.
There are no limitations on what the county council could do with that recommendation.
No, sir. There are no limitations.
It can go anywhere it wants under. Could it go over the recommendation?
I believe it could. Now, if they went too far up, the ordinance could be attacked for charging more than. In other words, the county council can't charge an impact fee that's out of the ballpark because it can only be for new growth and can only pay for new growth. If you understand, the background study has to consider what they think the student growth is going to be.
I guess my question, Mr. Grimes, is there anything binding at all growing out of the action of the school board?
No, sir. There is not.
Mr. Grimes, was the school board required to make a recommendation, or could the council have determined an amount on their own and based on their own study?
I think they could. That's what they did back in 1992. They made their own study. Now, the reason I think that the school board did it, because the 1997 ordinance said that the council was going to review their ordinance hence, 5 years hence, and that the school board and the home builders and anybody else could make recommendations. And obviously, when it came time for the county council to look at that again, the school board was the one that was interested in getting lots of things had happened. The cost of building schools had gone up, and so they made a study. They commissioned this study with this expert, Tyndall Oliver, that does that sort of thing.
But could the council have determined that the $5,200 or whatever the impact fee was the appropriate amount, even without a specific recommendation from the school board?
Yes, sir. There's nothing to keep them from doing that.
Did the county council invite others who wanted to do a study, to present a study in 2004 to say, if we're going to reconsider impact fees, and if you have an interest, you may present evidence, testimony, or experts, or do a study so that we can have information, objective information upon which to base our decision?
I'm sure they did. Now, the only thing I can address that specifically is the 1997 ordinance specifically said that when we look at this again, we will accept recommendations, and it said of the school board, it said the home builders, and then anybody else that wants to make a recommendation. So I think there was no question that people were invited to do that. Actually, the record does show that the home builders were talking to the school board people ahead of time, and they were also talking to the county council people ahead of time.
And when you say talking to them, what does that mean?
Meeting with the staff. They were meeting with the staff, not the commissioners, no. But they were meeting with the staff ahead of time. But the home builders didn't make a formal recommendation, but they certainly could have. And in effect, Mr. Watt's argument could be, I guess, characterized as a recommendation, because he made a comprehensive argument of why it ought not to be as high.
Can you briefly state why you think this is not a rule subject to 120?
Because it's only the action under the 1997 ordinance could only be a recommendation, and a recommendation can't be a rule. A rule, the courts have said that recommendations are only states of general applicability. Those statements which create rights or require compliance or otherwise have the direct and consistent effect of law, constitute rules. In other words, something binding going forward, something that somebody takes action later and they're bound by that particular thing. That's a rule. A recommendation which nobody has to accept can be nothing more than just an action by the school board.
Hypothetically, could the school board pass a rule that would bind the county commission or the county council?
They could not. There's no basis for saying that under the 1997 ordinance. Now, there could be an argument under the 1992 ordinance which required these automatic certifications that unless the county changed their ordinance at that time, when the school board made those certifications, it would have effect of automatically updating. And after 2005 of this new ordinance, the school board has to make some certifications which could have an effect of updating it, and you could make an argument that just changes the amount of the impact fee. But under the 1997 ordinance...
You have 7 minutes remaining.
Pardon?
You have 7 minutes remaining.
Okay, thank you, sir. Under the 1997 ordinance, there was nothing the school board could do. They were not required to make any kind of certifications. If they tried to make a certification, it had no meaning because the 1997 ordinance didn't require it and only talked about recommendations when they decided again in 2005. So
Okay.
I'd reserve the rest, please.
You have 6 minutes and a half.
Good morning, and may it please the court. I'm Alan Watts on behalf of the Volusia Home Builders Association. I'd like to set this case in context, and as you are well aware, this is an appeal from a determination of the administrative law judge, finding that the rule or policy of the district had not been properly adopted or repealed or amended. We begin with policy 612, which was adopted at the beginning of all of this by the school
Is that the
board.
1992?
Yes, sir. And the first sentence of it begins, "The purpose and intent of this rule is to determine and declare the policies of the Volusia County School Board for financing, construction, and utilization of educational facilities." The specific features of that rule are found in paragraphs 6 through 12 of the findings of fact in the administrative law judge's final order. The companion piece of that rule is County Comprehensive Plan Policy 15.3.4.4, which was adopted contemporaneously with that rule and is in force today. It says that the county has adopted, at the request of the school board, a level of service standard by reference for public schools. Now, that's part of the capital facilities element of the county comprehensive plan, and it deals with how the various services and facilities supplied by government are going to be supplied.
Is your argument that the companion to the school board policy 612 is binding, and the changes in the rule from 92 to 97 and again 2005 is still controlled by that policy?
Yes, sir. It is the county's policy. The county has delegated to the school board the prerogative, which I think is constitutionally with the school board anyway, the prerogative of saying how the level of service will be established for school facilities. I don't think that the county can impose a level of service on the school district. Constitutionally, that just doesn't work.
Mr. Watts,
Yes.
if you're successful on this appeal, is the impact fee still $5,284?
It is, unless and until the underlying study of the school district is tested in rule adoption proceedings. But see, what we're being asked to do is to collaterally attack.
Was the council bound by that study from the school board?
The county specifically incorporated that study.
That's not the question. Was it bound by?
Is it bound? Yes, I believe that it is.
Under what theory or under what ordinance?
The county comprehensive plan, which controls its ordinances. Florida statute 163.3202 requires that the county adopt ordinances which implement its comprehensive plan policies. The comprehensive plan policy with respect to the funding of schools and the level of service on schools delegates that responsibility, or actually incorporates by reference, I think are the words in the plan policy, the policies of the school district.
So are you saying that the county council was bound by the decision of the recommendation of the school board?
I don't think that the county can set any different level of service than the school board prescribes for school facilities. And the impact fee must be based on that level of service. You have to know the unit of
So
demand.
if the school board disagreed with the impact fee because it determined that the level of service could be satisfied by a lesser or greater amount, it could impose that fee rather than the fee suggested by the school.
I do believe that, and I believe it for constitutional and statutory and local policy reasons.
You see where we're all seem to be drifting.
Yes.
Well, this doesn't look like a final order of any kind. I mean, it doesn't look like a rule because it appears to be no more than a recommendation. If it's only a recommendation, then it's not a rule. I mean, that I think is what we're all looking for to fix.
Well, I agree with you, and that begs the question. What the administrative law judge said was,
I wasn't begging for anything.
what the administrative law judge says is, here they took this action, which is going to be incorporated into the county ordinance.
Maybe. Here's a problem I have. You have parallel bodies.
Yes, sir.
One has an ordinance that says in 92 we'll do it this way, in 97 we'll do it this way, and subsequently in 2005 we'll do it this way. 2005 and 92 is similar.
Yep.
Now, the school board said, we're going to look at objective data, and we invite everybody by December 04 to put something in writing to us to assist us in determining an impact fee. The school board went ahead, hired a consultant. They invited the home builders to do that. They did not. And they said, we've looked at it, we've debated it. There was a recommendation. In fact, the home builders agreed in principle to a figure less than $5,000. And then the school board made their recommendation, and the county council said, we've heard it, we've heard public testimony. Some of our members say one thing, some say another. We're going to go ahead with this figure. That is a recommendation from the Volusia County School Board. How is that a binding rule that would tie the Volusia County Council? It's a recommendation, as would be a recommendation from the home builders, which they did make.
The county policy says that the county will accept the level of service by reference as it's established by the school district. The only action which the school district has ever formally taken to establish that level of service is Rule 612. It is true that the Tyndall-Oliver report, which was done under the sponsorship of the school district, by contract with the school district, and incorporated into the new county ordinance, specifically by reference. That report varies the policies that are in Rule 612. Rule 612 could have been amended. It could have been repealed. It could have simply vanished from the rule book, but it did not. It remains in force.
So that we're clear, you're arguing that if the school board passes a policy, they can bind the county on the amount of impact fees.
Yes, sir.
And that figure may not be a reasonable figure in the eyes of the Volusia County Council, but that they would have to accept it.
And the place you test that is in the rule adoption proceeding, which never took place here, and we're asking that it take place. Otherwise, we have to collaterally attack the school board's data, methodology, and study by suing the county. And I'll draw a case to your attention by analogy. It's a case of City of Ormond Beach versus County of Volusia, in which the county adopted an impact fee to support the county arterial road system. Some of the cities objected to that, and they said, you can't do that to us. You cannot impose conditions on us for the issuance of building permits by our city building departments. And the case came here, and this court held that it is not a proper municipal purpose to obstruct the county in the performance of its lawful duties. The statutes assigned the duty to the county to run that system, and to obstruct the county in levying impact fees to finance that system was considered not to be a valid municipal purpose. Take that same situation and apply it here. It is the school board's constitutional duty and right to maintain and operate the public school system and to decide how it is to be financed. Can any government adopt an ordinance which says, no, we will not allow you to set a standard for schools in Volusia County because we control the power of the purse. We will not allow you to impose or decide what the impact fee should be because we think it should be something different. Well, the immediate effect of that, of course, is an effect on the quality and the service level that the school district provides. Does the county have that power independent of the school district? I think not.
Well, Mr. Bloss, let me ask you a question. At the meeting before the county council, would your clients argue for lesser, a smaller impact fee? Would, if the council had agreed to a $3,000 impact fee, would that have been valid and binding?
We believe that under the methodology which the school district propounded through the Tyndall-Oliver study, that there was a number that was closer to $3,000 than $5,000.
But the question is, could the council have legally passed an ordinance that said $3,000 impact fee?
If it adequately funded the level of service. Yes, sir.
Based on the situation they had at the council meeting, I guess in February of 2005, could they have said, not approve the motion for $5,284 impact fee, but approve the motion for $3,000 impact fee? Could they have done that?
If it can be demonstrated, as we believed that it
Well,
could.
based on that meeting, when they were there, could they have approved a $3,000 impact fee? Yes or no?
They were obliged to pass an impact fee that adequately funded the level of service.
Okay, well, could they have passed one for $3,000?
If it adequately funded the level of service.
Well, at that time, did you believe that it would?
We did, based on the school board's own methodology and data.
Okay, so with the administrative law judge's conclusion in paragraph 38, the petitioner has not presented any general or specific law applicable to the facts of this case which would not require complete obedience by the Volusia County Council with its own ordinance. Was that an incorrect statement then? Could they have gone less than? And that seems to suggest that the administrative law judge concluded that the council could only agree to $5,284, that they had no other option.
Now, council could only pass an impact fee which funded the level of service that was prescribed by school district policy.
Well, isn't that the issue? And that is that they provided a report along with data from the Department of Education that said this is the number.
And
This is the number based on growth, school costs, et cetera, pupils, what we anticipate. This is the number.
Yes, sir.
And your argument seems to be that they didn't have the authority to do that under their policy 612.
No, sir, they did have the authority to do it. And when they do it, we will challenge the data that support the conclusion. But we can't do that collaterally. We can only do it in the context of the school board's adoption and endorsement of its study. The only thing that looks like the adoption and endorsement of its study is the action that the administrative law judge addressed that took place in January, a month before the final hearing on the county ordinance. But the problem we have here is, whose study do we challenge? We can't sue the county and say, county, the school board's study was wrong. It's not the county's study, it's the school board's study. The school board adopted it, they endorsed it, they passed it on with their recommendation to the county. And the fact of the matter is that the school district, based on the Ormond Beach case that I argued by analogy to you, I don't think that a county, and particularly a city, could pass an ordinance that says we're not going to allow the school district to collect.
What would be the methodology, in your opinion, under 612 that would be acceptable pursuant to that rule?
I'm sorry?
What methodology under the policy 612, you're arguing 612 is still binding, what methodology would be acceptable to your client or the FLE recommendation to the Volusia County Council?
I think the methodology is established by case law. It is to determine the pro rata cost of expanding school facilities at the level of service which the school district prescribes.
Well, that's fine. My question is, you don't question the Tyndall study's expertise, at least not in the ALJ presentation you made. So what is it that was not done or was done that should not have been done? How is it that 612 was not properly implemented in this recommendation?
First of all, 612 is considerably out of date when you consider its prescription of...
Regardless, you said it's the one that applies.
Well,
so under that application, what should have been done or what was not done that would make a recommendation based on 612 applicable and binding on the Volusia County Council?
If we were going to go back to 612 and not to a new set of policies that are embedded in the Tyndall-Oliver report, if we go back to 612, some of the things that are expressed in there are that the school district will first look at year-round schools in order to get maximum utilization out of their physical plants. When an elementary school is above 700 students, we'll look at staggering, 4 quarters a year and have three of them, the kids attend any 3 of those quarters. That's the policy that is now on the books for the school district. They don't follow it. They haven't repealed it. But that's what it says, that we will get maximum financial efficiency out of our...
Well, first you argue that the rule still applies, and then you argue that the rule is ineffective because circumstances have changed. Is that fair?
Yes, sir. The rule must be amended to reflect the changed circumstances. And when you do that, that exposes the data and the methodology to question in a
Part of the evaluation in order to determine an impact fee is from the Department of Education, and it sets criteria. Are you arguing that that criteria, even though followed, unless 612 is changed, the recommendation is invalid from the school board to the Volusia County Council?
The broad policies are established by the Department of Education. How those policies are determined with local programming, local fiscal decisions, is a matter for the local school board within the broad parameters set by state policy.
Would a homeowner who's paid impact fees based on a methodology contrary to 612 in the past, would he have the ability to go back and ask for a refund on all those years when the policy was, or a recommendation was made to the council, impact fees were imposed, impact fees were paid, and it appears that you're saying that it is no longer binding, has not been binding for years, and so it should not have allowed impact fees to be imposed?
Well, that's an interesting question.
Well, would you answer it then?
Yes, sir. I was just going to tell you that it goes back to a case that I argued in front of Judge Grimes 30 years ago. The ultimate outcome of the case was that it was within the power of the body imposing the impact fee to go back and cure flaws in the original methodology and come up with the right number and the right methodology and keep the money that had already been collected up to the point that was determined to be lawful.
So theoretically, they could have benefit of this improper recommendation and still keep the same $5,000 impact fee?
They can keep as much of it as survives a well-tried rule adoption process. And I don't want to prejudge what that number is. I know what we think it was, but we were arguing it as a collateral argument to the county. We think the school board's data are wrong. We don't think they are consistent with its policies, either the old ones in Rule 612 or the new ones embedded in the Tyndall-Oliver report but not formally adopted.
Have you ever seen a case or aware of a case from the record? There was discussion where the Tyndall-Oliver's objective recommendation has been found to be flawed, or that the protocols for presenting the recommendation were not properly followed. That is, they didn't do what they were supposed to do as experts.
We ran the same numbers based on the projected revenue from other sources that Tyndall-Oliver ran. The school board has a $2 million authority to collect for capital needs. They have some minor stream of state revenue, although that's greatly diminished in recent years. They have a need to maintain existing schools, and the discretion as to how much of that to apportion to maintenance is one of policy, of making a policy.
So the question is, have you found the case?
We ran their policies and the data, and we came up with a number that was significantly different from $5,000. But we can't really present that in a direct contest unless we're in a rule adoption proceeding, and we have been denied that opportunity. We need the chance to go back, and they need the chance to go back and repeal or amend Policy 612, and in that context, we will present all of those arguments, but it prejudges them to present them here or to the county.
Just so I understand you, is your argument that a new policy, let's call it 612, that is promulgated as a rule would bind the county council to the exact figure that they present for impact fees for the Volusia County School Board?
Yes, sir. I think constitutionally that's required, but particularly in this case, and one statute, by the way, that requires it is 163.3180, subsection 3. It says government entities that are not responsible. Shall I continue?
I believe your time is running out, and that's the first time I've heard that.
Oh, that's, yeah, we usually turn off the buzzer, but, you know, since we had special guests here today.
Thank you, sir. Your time has expired.
Thank you, sir.
That is the first time I've ever heard that thing go off.
All right, so you have 6.5 minutes remaining.
Yes, sir, thank you. Council admits that Rule 12 is out of date, it's obsolete. It has nothing to do with what the 1997 ordinance, which is as applicable ordinance when this is filed.
As I understand his argument, perhaps you should address it. His argument is not that the Volusia County Council ordinance is bad, it's that the Volusia County School Board 612 policy has not been changed, and it should be changed, and the recommendation they made was in derogation of the rule, or it presented a new rule that was binding then on the Volusia County Council.
Well, of course, to start with, if there's no, of course, there's no evidence in the record even that the rule, policy 612 is a rule as far as that goes. But if it's a rule, then in order to amend the rule, you've got to have another rule. And a recommendation can't be a rule. It was just lying, the 612 was just lying around on the books. It was designed, and you can see right in the predicate of 612, it was designed to do the certifications under the 1992 ordinance.
Yeah, it describes itself as a rule, by the way.
Well,
It says the purpose and intent of this rule.
I understand it said it was a rule, but if it was a rule, it's simply not relevant when the 1992 ordinance was repealed. Now, he says he can't attack the methodology of the $10 report in a suit against the county. That's being done right now by some apartment builders, and they're attacking the methodology of the report. You don't have this rule business is really beside the point. He says this comprehensive plan, statement of the comprehensive plan that he relies on, it's simply an acknowledgement in the comprehensive plan. Comprehensive plan, of course, is to plan for the future. It's an acknowledgement that the council has adopted an impact fee as a means of paying for some of the growth that they anticipate will be happening in the county insofar as the schools are concerned. There was no concurrency with the county comprehensive plan for schools in 2004-05 when this was adopted.
It appears he's arguing that the school board didn't follow its own existing policy and substituted a policy which he'd like to call a rule. Can you briefly discuss what is the viability of 612? That is, does it still exist? Is it still being followed? Should it be repealed and substitute the new methodology that they now use to make a recommendation to the county council?
I submit that the Tyndale Oliver report was not even a methodology as such. I mean, it was a new report and a new study, but it was simply it was still on the books. It had no relevance whatsoever once the 1992 ordinance was repealed. He admits that the council could have adopted the $3,000 and it would be valid. He tries to say they're bound by it, and yet he admits that the $3,000 would be valid. I think this is a simple case in the sense that the 1997 ordinance just authorized recommendations. This Tyndale Oliver report was simply a recommendation. And I confess, now Mr. Watts is a very competent lawyer, but I really don't understand, I confess I don't really understand his argument very well. And I kind of think he's fishing for a PCA, but in event.
That's a good legal argument.
I'll just say this, that if you understand it, and if you think he's right, and you feel that you've got to affirm the case on that basis, then I would respectfully ask that you write an opinion explaining why, and so the school board can get it right the next time. Thank you very much.
Thank you, gentlemen. Thank you. Well-argued case on both sides. Court stands in recess.